and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Friday, August 4th, 2023, but it won't be going out for a few days, a week, perhaps 2 weeks. We are doing some episodes in advance of some vacations, which often happens in August in the Northern Hemisphere, as many of you know. And so you will get your Short Circuit at a regular schedule, but on an irregular schedule on our end. But someone who is most regular and is a sometime regular guest on Short Circuit, and we are very happy to have today, is my colleague, Ari Bargil. So Ari, welcome back.
Thank you for having me, Anthony. Always good to be here.
So Ari is going to talk to us about betting on elections, something that is kind of legal sometimes, although not so much in our country. If you go, like to the betting shops in Britain, you can bet on like basically anything. But in the U.S., that's more frowned upon. And there's been certain ways to do that. But now it seems like there are less ways to do that because of some administrative law irregularities that came to light recently in the Fifth Circuit. So Ari's going to talk about that. And then I am going to take us on an international adventure, and I'll be presenting the second case, which will take place partly in, but mostly outside of, the Bolivian Republic of Venezuela. Republic of Venezuela. And I'm mispronouncing both of those words, as Ari has already told me, but I will do my best with my Spanish pronunciation. I did not take Spanish at school. I'm sorry, everyone, so just in advance. But we will be talking about a tale of investors and sovereignty, and governments come and go, but sovereignty remains, and all that cool international law stuff we'll be talking about later on. First, though, Ari and this outfit called PredictIt. So, Ari, what is PredictIt, and can I place a bet with them?
So the case is Clark v. Commodity Futures Trading Commission, and it involves, as you said, a company called PredictIt. And what PredictIt does is they provide a platform for people who want to place wagers on political outcomes. And so if you go to PredictIt's website right now, you'll see a whole slate of potential bets. One of the most, common bets that people can place on the website is on who will win the nomination for the presidency from the Republican Party. So here we have a whole slate of candidates. Donald Trump is in the lead with a handful of other followers, people who have also thrown their hat in. And the way that PredictIt works is essentially you can buy a share, which represents the chances that a candidate will win the nomination. The share price varies based on the likelihood of that person winning. So Donald Trump is currently trading at 59 cents per share, whereas Mike Pence and Nikki Haley are bringing up the rear at 3 cents per share. And if you're correct in your prediction, the share that you bought, say you bought Donald Trump at 59 cents or Nikki Haley or Mike Pence at 3 cents respectively, the share that you bought will mature to a value of $1 and you can cash it in. So if you bought a bunch of shares in Nikki Haley at 3 cents, if she wins the nomination, it's worth $1. You can cash that out. That'll be quite a windfall. Whereas if Donald Trump wins the nomination at your 59-cent share price, you'll cash that out at $1. Also, not quite the same windfall, but obviously this is based on probability. And what this is a reflection of people's confidence in who will win various political races. And this idea is the brainchild of a university in New Zealand. This is Victoria University, who decided, hey, wouldn't it be great if we could gauge future outcomes or predict future outcomes based on people's willingness to essentially put their money where their mouth is. Let's see who's likely to win an election, and let's see whether or not these markets are actually providing good predictive value. So the academics at Victoria University decided to set up this exchange. They acknowledged or realized that it would probably violate American federal law under the, which is regulated by the Commodities Futures Trading Commission. And so they sought something called a no action letter from the CFTC, basically asking them in advance, hey, please tell us that you won't enforce any of your regulations against us. This is an academic project. We're going to limit it. We're going to only allow something like 5,000 total traders on the platform. And we're going to limit investment to $850. And the CFTC said, okay, you can go ahead and you can get this started. They hire this third party called PredictIt, who's going to set up the platform. And this is in 2014. And so
and Ari, sorry, before we go forward, is the reason why, I mean, they're in New Zealand, they're setting this up, is the reason why they bother talking to the CFTC is because they want Americans in the United States to be part of this, because it's going to be more real that way and not just have, people in New Zealand or the UK or wherever else doing the bets, where it sounds like they wouldn't have this problem.
Yeah, the opinion doesn't touch on this, but I suspect that's right. And one of the things, and obviously if you're offering this with American political candidates and you want to predict the outcome of American elections, the people with the most knowledge presumably would be Americans, right, as opposed to outsiders offshore. So with the knowledge that this is going to operate within the United States, they had the sense to get in touch with the CFTC to get this no action letter, which in 2014, like I said, the CFTC issues. And what the letter essentially says is, hey, we're not going to enforce against you, subject to these terms. And PredictIt then opens up its doors essentially, and people can begin to wager on political outcomes in the United States. But in 2022, a division of the CFTC, the DMO, I forget what the acronym is, and I had it written down, but a division of the CFTC rescinds the no action letter, and they accuse PredictIt of having violated the letter's terms. The only problem is they don't tell PredictIt precisely what terms of the no action letter they violated. They don't say what the evidence is of this violation, and they don't tell them why they've got to stop operating within a certain period of time. They just say your no action letter is rescinded. This, of course, results in chaos and upheaval at PredictIt. They're not really sure what their rights are, whether they have to cease operating. And as a company that's been in operation for 8 years by this point, there's quite a bit of money on the line, and quite a high number of participants who've already placed wagers, whose wagers are now in limbo. So they file a lawsuit. And they seek a preliminary injunction. They say that the rescission of the letter was arbitrary and capricious, among other reasons, because it didn't say why the no action letter was revoked. And the preliminary injunction just kind of sits. And if you know anything about why people seek preliminary injunctions, it's usually because they need a ruling, and they need a ruling right away. Usually because there's a lot of money on the line, or there's a certain event that's going to occur that's irreversible. And so they need their decision at the front end rather than at the back end, because litigation takes time.
PI motions don't age like fine wine.
That's very true. And yet this PI motion sits. And so the PredictIt appeals this to the Fifth Circuit, even without a decision, saying, hey, the fact that this has sat for so long is effectively a denial. Please take it up. And CFTC raises a whole bunch of arguments in response to the Fifth Circuit's, taking this up here, mostly on justiciability grounds, saying, hey, this is improper. And one of the things they say is this is moot, because weirdly, after oral argument, the CFTC, I'm going to make sure I get this framing right, the CFTC withdrew its rescission of the no action letter. And what it did with that withdrawal is it replaced it with a different letter saying that the no action letter is still void and should be withdrawn, and providing a little bit of explanation on why the no action letter was originally withdrawn, but also saying that this new letter is just advisory, and so you can't really rely on that. And why do all these letters matter? Because, the CFTC comes into court and they say, well, the rescission that you're suing about, the rescission of the no action letter, that's been withdrawn so the case is moot. And you know, we said in another letter basically that you still can't operate, but that's a whole different letter, and so you know you can't challenge that either. And the court, to its credit, the Fifth Circuit, basically, you know, they're unpersuaded by this. The CFTC says, hey, this cuts the legs out from all of your arguments because we've now given you a bit of an explanation. And the court just says, look, these are hijinks. There's still obviously a dispute about whether PredictIt can operate, and so this chicanery is unpersuasive. But the CFTC also says this wasn't final agency action. You know, we just provided this advisory letter, and you were a fool to rely on it. And the court rejects that too, because the letter said explicitly that you may rely on it, and that's kind of the end of the inquiry. And it doesn't matter that there's now this new letter. You violated the terms of the old letter. And you know, you told PredictIt that they violated the terms of the old letter and that they need to change their conduct, and that's final agency action. You know, the agency also says you don't have standing because Victoria University isn't a party to this lawsuit, and the court, you know, quickly brushes that aside and said, hey, you know, the parties who did file this lawsuit stand to lose quite a bit of money. Their financial situation is already very much in doubt as a direct result of the conduct of CFTC here. So all of these justiciability arguments, it's kind of setting aside, and it moves directly to the PI factors. And it says, look, there's a substantial likelihood of success here because, you know, you're going to have to come in and show, PredictIt, that the rescission of the no action letter was arbitrary and capricious. And here they gave absolutely no reasoning whatsoever for why they were rescinding the letter. And the court calls that the epitome of arbitrary and capricious action. And they also say this new letter that you gave can't save you. It's got some of the same infirmaries as what you did before. And it's plainly a post hoc attempt to rationalize what you did after oral argument. You know, the court also acknowledges that there's going to be irreparable harm to PredictIt because they're suffering loads of financial harm being in limbo like this. And they also acknowledge that the balancing of the equities and the public interest tip in favor of PredictIt, because while they're sympathetic to the CFTC's argument, that there's going to now be all this litigation over no action letters, and that's going to disincentivize agencies from issuing no action letters to begin with. The court also says, well, yeah, that might be true, but if we don't find in favor of PredictIt here, that's going to incentivize awful behavior like this on the part of administrative agencies, and we can't let that go either. So ultimately, they brush aside these jurisdictional arguments. They grant the preliminary injunction, or they remand for the district court to enter the preliminary injunction and allow the plaintiff's claims to be heard on the merits. And in the course of doing that, they did something that we'd like to see courts do more of, which is kind of take the agency to task for the gamesmanship that's very obviously afoot here with the issuance of letters, the rescission of letters, the insistence that by getting rid of one letter and replacing it with a new one, that you've mooted the case and that the right parties aren't here, and all of this legal gamesmanship that we often see from agencies, especially after lawsuits are filed, to evade merits decisions. And so here we're going to get a merits decision from the district court. It's going to go back to the Fifth Circuit almost certainly. And we'll actually get a ruling here on the propriety of telling somebody that they can no longer operate after you told them that they could operate, without having told them why they can no longer operate after you told them that they could operate. And that is the story of PredictIt. I hope it's not too convoluted, but that in a nutshell is what's going on at the Fifth Circuit. And there's some interesting concurrences and dissents if we want to talk about those as well, Anthony.
Yeah, well, let's get to those in a moment. By the way, the DMO is the Division of Market Oversight. That's right. At the CFTC. So those guys could not prosecute because of this letter. Although it sounds like they're basically the only ones who would anyway. Just the predict what PredictIt does, and that the conversation about prediction markets is fascinating, and we could have that conversation sometime, and their utility and why they're basically illegal in the United States in all kinds of ways, which is really stupid policy, I think. But on this administrative law kind of run through, it just sounds, the basic administrative law principles one way of thinking about them, I think, for listeners who are maybe more familiar with like some of IJ's work under the rational basis test, where whatever you if there's a regulation on what you want to do and you think it doesn't make any sense, you essentially have to, unless you're lucky enough to have a quote fundamental right you're dealing with, you have to show that there's absolutely no rational basis anyone could come up with for why you would want this law. But the administrative law sometimes shades into that, and sometimes it's a little beefier than that kind of review. But the one thing that's the big difference I find in administrative law work is that the agency has to give the reason. Now, if the agency gives a reason, then they get all kinds of deference as to whether that reason is, quote, usually the standard is arbitrary and capricious or not. But they have to give a reason. And so the fact they didn't give a reason at all, I think, was like an alarm bell with some of these judges that, there is something not right here. And that allowed some of these other inferences to be made, or that maybe normally in a case wouldn't be made, like all this technical administrative law stuff. Like, is this a final agency action? Which the dissent, is arguing that this really doesn't seem like a final action. These interim letters that are going on, and a bunch of other steps like that that you outlined. It seemed that the reason why that kind of the CFTC got caught with its pants down, basically, is because that first letter was just so atrocious. And PredictIt had some good lawyers, and they were able to show, like, look, we have all this reliance on this letter, and then you take it out, really in completely arbitrarily, because you don't tell us what we've done wrong. And I think, finally, of course, it helps that this is not some, hedge fund doing shady stuff, which a lot of this, type of area usually is when you're dealing with the CFTC or SEC regulations. This is like a few academics trying to do research, and these bets are not huge. They're less than $3,500 or something is the cap that you can even bet on this stuff. So I think all that allowed this injunction to happen. But even then, it seems like going forward, they're still kind of by the skin of their teeth that they can stay in business.
Yeah, you're right about all of that. One of the things that the concurrence starts out with is this acknowledgement that, although we've said here that this might be final agency action, other circuit courts have actually said the opposite, that that these letters are not final agency action. And yet, given all of the misbehavior by the CFTC here, the court said, yeah, but we'll get to that, or the concurrence says, but we'll probably get to that, later on, after the district court enters its order issuing the preliminary injunction and then deciding the case on its merits. Now that, the dissent, as I think you pointed out, says, I'm not even sure they deserve an injunction here. But, given all of the background here, and how improperly the CFTC went about doing what it did, I think that bought PredictIt some time to get back into court and to be able to make its case. You also noted the harmlessness of what PredictIt does. This is an academically fruitful endeavor. It provides data that oftentimes is far more reliable and accurate than some of our traditional political polling. And I think the fact that it's been able to exist for 8 years sort of underscores how silly as a policy matter it is that it would be barred to begin with. One of our colleagues, Jeff Rose, likes to talk about how, if you look at something that's allowed to exist for 8 years without incident, that's probably a pretty good indication that it's a harmless endeavor. You wouldn't allow, other presumably illegal markets to operate for 8 years if they were problematic in any way. And so I think you can, just by virtue of the fact that they've existed without problem for a long time, shows us that laws barring their existence generally in the absence of no action letters are probably pretty silly and ill-advised.
Absolutely. Well, we wish PredictIt the best of luck, but yeah, it does seem like it is a touchy situation. The one last thought I had is that the very short concurrence by Judge Ho, it makes it sound like he's erring on the side of caution that let's give the injunction, allow the case to go forward, and preserve the status quo. Who knows what the merits are going to be? That kind of raises the question, because he doesn't dig into this, but there's this 4-part test that everyone always uses for injunctions, especially preliminary injunctions. And always the biggest one is likelihood of success on the merits. And then there's irreparable harm. And then there's a couple kind of more loosey-goosey ones about public policy, essentially, and balance of the equities. And usually, especially when the government's involved, it mostly comes down to likelihood of success on the merits. And courts often, and the Supreme Court's kind of said this, and different circuits have said this, that when at least in a constitutional challenge, you need to have likelihood of success on the merits. You can't, not have, so in a private context, sometimes you can have, I don't know if you're over 50-50 with likelihood of success on the merits, but the irreparable harm is just so massive, right? It's going to, if you don't get this injunction, the case goes away. Sometimes that can be if like a bond that a business needs to post or something like that. And so in Judge Ho is kind of saying here, I think it's less than 50-50 that you're going to win, but we'll let it go forward anyway. I mean, he's not saying that explicitly, but I get that sense. And I wish that, that was articulated as an actual rule, because sometimes you have situations like that.
Yeah, I read it the same way. And I do find it interesting the way he articulated, or at least presented it. Hey, you might not win, but it's close enough that we'll allow it to continue, or at least allow the injunction to issue, so that you're not totally destroyed while we're figuring that part out. I agree it would be better if it were just a little bit more explicit, but I'm sure PredictIt will take what they got here and be happy and get back on down to the district court where they can hash it out.
Well, someone else who is going to be happy about what they have got are a group of investors in some gold mines. This is a rather different story than the one we just told, but it is also an international one. And again, I'm going to say a few names that and words that I am not going to pronounce correctly, so apologies in advance. So most folks out there listening know a bit about the saga of what has happened in the country of Venezuela the last couple decades. So Hugo Chavez, right, is democratically elected to be president of the country. He keeps getting reelected, but he keeps getting more and more kind of dictatorial over the years. And then the country starts teetering on the edge of really being a dictatorship. He then passes away, and his successor, Maduro, comes to power. And then there's an election in which, even given all the stacking of the deck that had happened, he loses. And well, most people recognize that he loses. But instead of allowing this new government to come to power, I know I'm getting some of the details here wrong, but essentially there's a new Congress comes to power. Maduro sets up this kind of new Congress, that constitutional body that everyone recognizes isn't legitimate. And then eventually, when his term expires, the international community recognize the head of the Congress. It would kind of be like the Speaker of the House in the United States, like becoming president because there's no new president. That this guy Juan Guaido, then is recognized as the president of the country, even though within the country he effectively doesn't have that power. So that's kind of the backstory on what's going on here. But meanwhile, back in the days of Hugo Chavez, the government is doing things like nationalizing stuff. And there are some gold mines that are nationalized, and there's also some other of this business going on, and some international investors are not very happy about that. And one of the things they do is go to an international arbitral panel. So international arbitration, which has been a big subject of controversy for a few decades now, but they were able to do this, and they get a $1.2 billion award. So that's pretty nice to compensate them for some of these nationalizations, which were not compensated at the time. And then they're like, okay, well, we're going to go collect on our judgment. Well, how do you do that? Well, when it's a sovereign state you're trying to collect a judgment for, things get complicated. So this has been in litigation for a long time. This is just the latest kind of chapter, and it is in the Third Circuit. This case that was recently released, and the top line is OI European Group BV versus Bolivarian Republic of Venezuela, but there was all kinds of parties involved. But to tell the full story, we have to go back a little earlier, in fact, a lot earlier, to some kind of basic ideas of international law and sovereignty. If you go way back, the idea of sovereign immunity is not just a thing for, say, the United States or different states or the United Kingdom before the United States, but it's a recognized principle in international law with other countries as well. And so if you go back in the United States history, the United States recognizes other countries as having sovereign immunity. And so if you sue in the United States courts, you sue a foreign nation, that can be a tricky business. Now, for a while, the U.S. tried to deal with this with like letters from the State Department and recognitions of sovereign immunity. And this got to be just kind of it's very politically influenced, of course. It got to be a kind of a sordid business. And so finally, in 1976, Congress passed a law to have these kinds of questions where like a creditor is asking for money from a sovereign nation to go through the courts to try to depoliticize this process. So these investors, with that backstory, these investors go to the courts to try to get their money. Now, Venezuela, as people know, has a lot of oil, even though this case itself, the judgments weren't about oil. But that oil manifests itself in all kinds of different entities. And there's a couple entities in the United States that are essentially owned and controlled by the Venezuelan state. One is PDVSA is the acronym, and there's another entity, and actually the one that people might recognize is they in some way are whole owners of Citgo. So Citgo gas stations, if you trace it all the way back, that's Venezuela. So they get these judgments, they try to collect against the Venezuelan government, but then we have this change of control of the Venezuelan government in 2019 that I talked about earlier. Now, the interesting thing about that is the Maduro regime, of course, was continuous in Venezuela, even if it was not constitutional in Venezuela. But because other countries recognized this other fellow as the president, he was able to control, or had control, he and his opposition leaders, or formerly opposition leaders, were able to have control of these outside Venezuela entities, including this one in the United States. So they actually come in and say, look, that judgment was, again, they're trying to attach the assets of these oil entities in the United States. And they say, that judgment was the old government of Venezuela, but we're the new government that's, friendly with the United States. And so we can't be bound by that own credit. It's almost the same thing as you'd say, well, there was a revolution in the country. The new people running it for purposes of these assets are a completely new set of people. So it's almost like we're not in privity with that former judgment. And the court says that this is a tale as old as time, that sovereignty does not change. The governments come and go, but the sovereign stays the same. And the sovereign is the state. So this is the distinction, and you get in international law and in constitutional law, between the government and the state. This is some parts of U.S. history. You see examples of that. Like, there were treaties made under the Articles of Confederation for the brief period where that was like the United States government. And then we have the Constitution comes along. And from a point of view of international law, there is no difference in those two time periods. The court even talks about, the Third Circuit talks about an example of the Soviet Union after the Russian Revolution. It was a couple decades after, came and made representations in court in the U.S. that they were not the same thing as the Tsar of Russia previously. And the court said, no, you are the same sovereign as the previous one, even though, of course, the Soviet Union and the Russian Empire under the Tsar are completely different kinds of governments, but the sovereignty stays the same. And so because of that, in an odd way, because of that continuous sovereignty, there's no sovereign immunity for for attaching to these assets. And so these creditors can go and get paid. And so even though the underlying creditor stuff, might be interesting to people who are interested in international finance or that kind of thing, this is a very important point to know about how the international system does not like to see states come and go. They like continuity. And so this idea of the sovereignty of the state as being, something that we're not going to recognize as different unless, something really weird happens, like say Venezuela subdivided into 4 different nations. And then there, things might be a little bit different at that point. But generally, if it's the same land and you're talking about the government of that land, then you are going to be the same sovereign, even if you have like 2 competing basically sovereigns at the same time, which is what you had after this constitutional crisis in Venezuela. So, Ari, do you have opinions on constitutional crises and sovereignty?
Well, the one thing that struck me about this, and I don't pretend to be an expert in international arbitration or foreign nation immunity, but the one thing that struck me, and I'm grateful for this is a uniquely American viewpoint of what state sovereignty is. And by that, I mean, the court here says, look, nation states are fixed things. They are lines on a map that represent, collections of people and their governments. And those things stay the same, even though regimes and leadership comes and goes. And I think that's the best of all possible ways of looking at this. But I paused for a moment to acknowledge that isn't intuitive to many people the world over. And I'm grateful that it is intuitive for folks like us, despite all, a lot of our recent upheaval and some of the rancor. It's always just true that institutions remain and the nation itself remains intact, as opposed to other places in the world where when one leader leaves and another one, often not willingly, and another one takes their place, it essentially becomes an entirely new country. And this is the norm in a lot of places, including, Central and South America, where you see a lot of regime change and entire systems of government changing literally overnight. And so it makes sense to me that this would be an argument, made by Venezuela here, because I think it's something that intuitively makes sense, to folks in certain parts of the world. But it doesn't surprise me that it didn't land well in an American court.
Right. And yeah, I think, this is generally a rule that has been with the the Western powers system since the Peace of Westphalia, or all that business going back a few centuries. But it is definitely not a universal, not a necessarily intuitive universal understanding of different countries, and so it might take a little bit to wrap one's head around. But you can see that the reason why we have this, because if it was like a different government doesn't have to abide by what are these rules that the old governments were. I mean, that makes sense. From a libertarian perspective, actually, I can see why that you would like that, but then things would be a lot more complicated in how different countries and different private actors relate to each other. And so this idea of continuous sovereignty is just kind of something that a legal fiction, if you will, that we all have to abide by in order to make the world go round. And to close, there was a really interesting quote that the Third Circuit has, quoting a case from the Supreme Court from 1936, where they said, "Now as before, rulers come and go, governments end and forms of governments change, but sovereignty survives." So somewhat mysterious there. Well, someone who is not mysterious but is an excellent guest in Short Circuit is Ari Bargil. So Ari, thanks for coming back. We look forward to your next appearance. And in the meantime, I hope that everyone else will get engaged.